I will present on the introduction of Whistleblowers Protection Act. So there has been a significant increase in understanding of the value of blowing the whistle to ensure accountability and openness and prevent potentially damaging situations. Whistleblowers can be used as a means of improving the internal organization culture. Moreover, whistleblowers have been lauded as heroes for exposing instances of fraud within organizations and for assisting in preventing mistakes that could have had disastrous consequences. Whistleblowers are more likely to have professional positions inside the organizations, have worked there for a while, and have a more favorable attitude toward their professions. Okay, so now we move to the definition of whistleblowing. Whistleblowing is described as when an employee believes his or her employer has committed a wrongful or detrimental conduct to the general public and reveals the elite to the media, government, or any organization's top management official. According to Lawrence and Weber 2014, the term whistleblower refers to the informant who reveals that someone has engaged in or is engaged in acts that are prohibited by laws or regulations.
Next is Whistleblower Protection Act 2010. Employees who report violation of rules, laws or regulation as well as mismanagement, gross financial waste, power abuse or a measure, and specific threats to the public health and safety are protected by the Whistleblower Protection Act. The Malaysian Anti-Corruption Commission, MACC, the Royal Malaysian Custom Departments, the Immigration Departments, the Road Departments, and etc. are all involved in this protection. The Bank Negara Malaysia also committed to give the protection to the whistleblower. Moving on, there are 4 types of protection for the whistleblower. The first protection is, even during the court case, the informant identity and their data cannot be provided and will be kept private. The second one, whistleblowers shouldn't be subject to any legal criminals or disciplinary repercussions for making such a report. The third one, whistleblowers are shielded from any action that could harm how disclosures are received. And the last one, those who have any relationship with the whistleblower also will be protected. So for an example, the Central Bank of Malaysia, a whistleblower who is in a good faith that informs the bank about all the unlawful activities will be granted the following protection. The first one, a person's identity must remain private. They are immune from legal and criminal consequences for disclosing it, and they are protected by any harms. The Whistleblower Protection Act of 2010, Section 11 will nullify whistleblower protection and exclude the following disclosure. The first one, where the whistleblower has participated in the improper conduct. The second one, where the whistleblower violates the whistleblower protection. The third one, where the disclosures of improper conduct are frivolous. The fourth, where they primarily contest the validity of government policy, where they are made solely to avoid dismissal or other disciplinary actions, and the last one, where they are made knowing the disclosures to be false or untrue.
So first, let me introduce you to one institute, which is Institute Professional by Toma. So, IPB is a private limited company incorporated in Malaysia on 23 April 2022. IPB was founded by Baitulmal Corporation Malaysia, a government-linked foundation responsible managing religious endowments. IPB is a registered training provider with the Malaysian government, and its courses are coordinated by the Malaysian Qualifications Agency, MOA. The company is also a member of Association of Private Colleges and University Malaysia, APMC. So, IPB is a headquarter in Kuala Lumpur, Malaysia, and has a network of campuses in several other states in the country. The company has a student body of over 3,000 and it employs over 200 staff. So the objective of IPB is to provide high quality education and training to the underprivileged and marginalized communities in Malaysia. The company offers a wide range of courses including diploma, certificate and foundation program in business, accounting, information technology and other fields. So, let me move on to what is the case regarding IPB with Whistleblower Protection Act 2010. So, the whistleblower, Sheikh Omar bin Sheikh Agil, was the Chief Executive Officer of IPB at that time. He allegedly exposed that there was financial mismanagement and irregularities at IPB of his co-workers. Sheikh Omar's allegations were investigated by the Malaysian Anti-Corruption Commission (MACC). The MACC found that there was evidence of financial mismanagement at IPB. As a result, the MACC charged several IPB officials with corruption. So first, let me move on to the issues. There are two issues regarding IPB. In accordance with the Whistleblower Protection Act 2010, the Sheikh Omar qualifies as a whistleblower. So, Dr. Sheikh Omar holds a position as the CEO of IPB. He is really courageous and daring to submit various disclosure of improper behavior by staffs of IPB to MACC and PDRM. The Whistleblower Protection Act defines a whistleblower as an individual who makes a disclosure of improper conduct. In this case, Sheikh Omar disclosed information about a financial mismanagement and irregularities at Institute Professional Baitulmal to the police and the Malaysian Anti-Corruption Commission (MACC). This information constituted improper conduct under WPA. Therefore, court has reached conclusion that Dr. Sheikh Omar meets the requirement to be considered as a whistleblower under Act Protection 2010. Second issue is whether the IPB has taken detrimental actions against Dr. Sheikh Omar. IPB took various disciplinary action against Dr. Sheikh Omar, asserted that as a form of retaliation. These actions included suspending him from his duties as CEO, issuing him a warning letter, instigating an internal investigation against him, and filing a police report against him. Some of the specific sections that IPB took against Dr. Sheikh Omar is on October 6, 2015, IPB issued Dr. Sheikh Omar a notice of investigation for alleged misconduct. On 7 October, IPB suspended Dr. Sheikh Omar from his duties as CEO. On October 19, IPB issued Dr. Sheikh Omar received a warning letter for alleged misconduct, and on November 23, IPB filed a police report against Dr. Sheikh Omar for alleged criminal breach of trust. Finding from the cross-examination done by the court has found that allegation of alleged misconduct Dr. Sheikh Omar made by Institute Professional Baitulmal are more of an afterthought designed as desperate defense. So lastly, the court also ordered IPB to reinstate Dr. Sheikh Omar to his position as CEO. So finally, the results of the case is Dr. Sheikh Omar has won the lawsuit against IPB with the case. The High Court judge issued a ruling that Dr. Sheikh Omar was successful in his bid to strike out the notice of internal investigation against him. The judge also came to the conclusion that IPB was unable to demonstrate that the action taken against Dr. Sheikh Omar was not a form of retaliation. Court has ordered that IPB to pay 18,750 relief costs to Dr. Sheikh Omar Sheikh Agil.
Now, let's look at the comparison between Malaysia and United States whistleblowing legislation. Now, let's look at the United States SOX 2002.
Employees in the United States need only show that the protected disclosure was a factor in the resulting disciplinary action. In the United States, employees who are retaliated against for whistleblowing do not have to prove that their whistleblowing was the sole reason for the retaliation. Instead, they only need to show that it was a factor in the employee's decision to take action against them. This is because it can be difficult to prove that whistleblowing was the sole reason for retaliation, as there are often other factors that could have contributed to the employer's decisions. Next, the burden rests on the employee to show that the protected disclosure is one of the factors that leads to the detrimental action taken by his employer. The burden of proof is on the employee to show that their whistleblowing was a factor in the employer's decision to take action against them. This means that the employee is responsible for gathering evidence to support their claim, such as documentation of the whistleblowing, documentation of the retaliation, and witness statements. A reward is only granted to a whistleblower in the event of a successful judicial or administrative action taken against the companies involving monetary sanctions exceeding USD 1 million. A whistleblower is only eligible for a reward if the government takes successful action against the company, such as filing a lawsuit or issuing a fine. The reward is typically a percentage of the monetary sanctions that the company is ordered to pay. The amount of the reward can vary depending on the law that was violated and the amount of money that the company was ordered to pay. The Dodd-Frank Act imposes a duty on the Securities Exchange Commissions to make an award to the whistleblower. The program is designed to encourage employees of securities firms and other financial institutions to report potential violations of the law. The Dodd-Frank Act requires the SEC to pay a reward to any whistleblower who provides original information that leads to the successful enforcement of an action brought by the SEC that results in monetary sanctions exceeding $1 million. The amount of the reward is typically a percentage of the monetary sanctions that the company is ordered to pay, but it can be as high as $30 million. The WTA is more general than the Dodd-Frank Act when it comes to the provision of rewards to whistleblowers. The WPA does not specify the amount of the reward or the circumstances under which it can be paid. Instead, it leaves it up to the government to decide how to reward whistleblowers in each case. The WPA also does not specify where the reward money comes from. In the case of the Dodd-Frank Act, the reward money comes from a designated fund. However, the WPA does not require the government to set up a designated fund for whistleblower rewards. Instead, the government can use any source of funding, such as taxpayer money, to pay rewards to whistleblowers. Now, let's look at the Malaysia WPA 2010. The Whistleblower Protection Act 2010 is a valuable tool for protecting whistleblowers. However, it is important to note that the WPA does not guarantee that whistleblowers will be rewarded. The government has the discretion to decide whether or not to pay to a whistleblower, and the amount of the reward will vary depending on the circumstances of each case. The scope of protection on the kinds of information to be disclosed is wider compared to the United States position, as the disciplinary offense under the WPA 2010 includes breach of code of conduct and ethics. Only the WPA 2010 extends the protection to persons related to or associated with the whistleblower. Only the WPA expressly allows the whistleblower or anybody related with him to change their place of employment. The Whistleblower Protection Act 2010 specifically says that civil or criminal legal action cannot be conducted against a whistleblower. WPA 2020 makes it illegal to obstruct an unauthorized officer in the performance of his duties under the WPA 2010 in order to strengthen the investigation and detection of improper conduct. WPA 2010 does not provide the time limit in which a whistleblower can complain to the enforcement agency that he has suffered from detrimental action as a result of his protected disclosure. In conclusion, the Whistleblower Protection Act 2010 is a valuable piece of legislation that helps to protect whistleblowers in Malaysia. However, the law still has some shortcomings and more needs to be done to strengthen it. By ensuring that whistleblowers are truly protected from retaliation, we can encourage them to come forward and report wrongdoing, which will help to create a more transparent and accountable society. That's all from us. Thank you.